You ever heard of professional strike breakers? Well, the use of professional strike breakers is prohibited in the state of California. And the law that addresses professional strike breakers is contained in Article 1 of Chapter 8 of Part 3 of Division 2, that's a mouthful, of the California Labor Code. Section 1130 of the Labor Code sets forth several legislative findings and declarations, including that relations between organized labor and management in this state have for many years been marked by a mature adherence to the principles of good faith, collective bargaining, and mutual respect for the rights, interests, and well being of working people, business, and industry. And the importation or use in this state of professional strike breakers as replacements during the strike or lockout endangers such sound and beneficial relations between labor and management. Section 1132 states the definitions contained in this law govern its construction, and Section 1132.2 defines employer, and Section 1132.4 defines employee. Employees any person who performs services for wages or salary under a contract of employment that's either express or implied. Section 1132.6 defines the term strike to mean any concerted act of more than 50% of the bargaining unit employees in a lawful refusal of the employees under applicable state or federal law to perform work or services for an employer, other than work stoppages based on conflicting union jurisdictions or work stoppages unauthorized by the proper union's governing body. Section 1132.8 defines the term lockout to mean a refusal by an employer to permit any group of 5 or more employees to work as a result of a dispute with those employees that affect wages, hours, or other terms or conditions of employment. And Section 1133 of the Labor Code defines the term professional strike breaker. And this is a person other than supervisorial personnel who have been in the employ of the employer before the commencement of the strike or lockout, who has first worked for 2 or more employers during a strike or lockout, or 2, who offers themselves to an employer who has a strike or lockout in progress. This section also defines the terms repeated occasions, employment for the duration of such strike or workout, employment, and supervisorial personnel. Section 1134 states that it's unlawful for any employer to willingly and knowingly utilize any professional strikebreaker to replace either an employee or employees involved in a strike or lockout at a place of business located within the state of California. Section 1134.2 states that it's unlawful for any professional strikebreaker to willingly and knowingly offer himself or herself for employment or to replace an employee or employees that are involved in a strike or lockout at a place of business located in the state. And finally, there's Section 1136 that specifies that anyone who violates the law is going to be fined no more than $1,000 or imprisoned no more than 90 days or both upon their conviction. And Section 1136.2 actually contains a severability clause in case any provisions of the Act are found to be invalid.